Australia's leading expert smashes ASIC. Martin North, John Adams, in the interests of the people. Hi folks. Well, John and I haven't been able to make a show in the last 2 or 3 weeks. We're both extremely busy on other things, but nevertheless, the inquiry into ASIC continues, and there was some very compelling evidence given this last week. Not only were whistleblowers under the gun in terms of actually exposing what happens to them when they try and do the right thing, but there was a very, very important set of evidence given about the role of ASIC. And so we're going to play that now. And this is Senator Bragg leading the conversation.
I now welcome Associate Professor Andy Schmerlow. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. For the Hansard record, could you please state your name and capacity in which you appear?
Thank you, Chair. Those strictures have been relayed to me. My name is Andrew David Schmerlow, and I appear as an Associate Professor in the School of Law at the University of Wollongong.
Okay, thank you very much. Do you have an opening statement?
I do, Chair.
Please go ahead.
First off, my thanks for the opportunity to support an inquiry conducted by the Senate. It's a privilege for me to do so, and my employer, the University of Wollongong, appreciates opportunities for it to demonstrate the usefulness and practical application of the research that is conducted under its banner. In my remarks, Senator Bragg, I will confine myself to my area of specialisation, which is the regulation of the financial industry, and in particular ASIC's regulation of the financial industry. Your colleagues might be saying to themselves, why am I confining myself to such a narrow point of discussion when in point of fact ASIC's remit is far broader than that? And the first answer is because that's my area of specialisation. I can't talk about NUIX because I don't know enough about it. But the second is that the regulation of the financial industry is by far and away the biggest, most voluminous, most intractable, most important and most difficult part of ASIC's job. And my specialisation, my research expertise, such as it may be, has been such that I've been called upon to provide similar advice to the House of Commons and the House of Lords, the South African National Treasury, the South African Financial Sector Conduct Authority, the New Zealand Financial Markets Authority, the National Assembly of the Republic of Korea, CGAP, a division of the World Bank, and the Finance Ministry of Brazil. There are a number of issues that I would like to touch on, Chair, and all of those are under one overarching rubric. There is only one question that interests me. Why does ASIC not enforce the law? That is the only thing that matters to me, and that is the only focus that I will take today. Why does ASIC not enforce the law? And there are four topics that I'd like to cover if I have your permission. The first is that ASIC's remit is too wide. The second is instances of high-profile cases where ASIC declines to prosecute, and we're told that they have received legal advice to that effect. The third is the role of the CDPP. And the fourth is the role, or the potential role, that should have been played by the Financial Regulator Assessment Authority. That concludes my opening statement, Chair.
Thanks very much, Dr. Schmerlow. So I guess where we are now is looking at what would be the best mechanism to take the issue forward, as you identified, which is about law enforcement. I'm going to start with structure. So what do you think is, when you look around the world and you look at different approaches to corporate law enforcement, are there any particularly clean models that we could be looking at?
Yes, I think the South African model to date is the most standout. It's the most recent adopter of the Twin Peaks model, although it is about to be supplanted in that respect by Jamaica, which has announced that it'll be adopting the Twin Peaks model. The South African model is working exceptionally well because their regulator is very eager to enforce the law. They have a prudential authority which, with reference to the remarks that were made by Dr. Jones a moment ago, takes a much broader view of prudential matters and has insisted on a purview that involves corporate culture, which I think is the right way to go. You know, Senator Bragg, prudential regulation, if nothing else, let me leave you with this thought. We all understand that conduct regulation is about conduct, but I would suggest to you prudential regulation is about conduct too. And a prudential regulator that is conduct focused is a prudential regulator which I think is better suited to the task. The South African authorities, it must be said, do not suffer some of the constitutional impediments that ASIC suffers. So the regulator in South Africa can impose fines, very substantial fines, and all sorts of other punishment measures, and can only be opposed on very narrow administrative law grounds. ASIC, for constitutional reasons, doesn't have that freedom. But nonetheless, neither does the ACCC. And the ACCC is very widely acknowledged as being far better at law enforcement than ASIC. So it comes down to, it's not just a question of constitutional impediments, it's a question of leadership and it's a question of corporate culture.
So if you take the last recommendation from Dr. Jones, where he recommended that there be an unconscionable conduct provision for the ACCC to enforce across the economy effectively, including in financial services, how viable do you think that would be in the current context of already having APRA and ASIC with overlapping responsibilities?
I'm going to share a hunch, and it's nothing more than a hunch. I don't have any evidence to back this up. But I get the impression that there have been times in the past where the ACCC has found a reason to impose itself within ASIC's remit because they see ASIC doing nothing. For example, they ran an inquiry into the pricing of bank services some time ago. I think that I get the impression that there is some frustration at the ACCC in seeing instances in the broader economy that they would certainly take steps about and ASIC doing nothing. And I think that instead of giving the ACCC a confusing, unconscionable conduct remit, which would kind of be a broad catch-all for it to go after firms in the financial industry, let's just accept ASIC is so dysfunctional. And Senator Bragg, this is not my view. There is a 2014 Senate inquiry into ASIC which determined that they were weak, feckless and suborned. There were criticisms of ASIC in the Murray inquiry. There were criticisms of ASIC in the Treasury Capability Review. There was an excoriation of ASIC in the Hayne Royal Commission. Let's accept that ASIC is so fundamentally broken that it cannot do the job. And let's take a regulator that is exceptionally good at what it does, the ACCC, and give them the power to enforce market conduct and consumer protection in the financial industry. Let ASIC do all the other stuff. All the other stuff that they enjoy doing and that's not controversial and that doesn't require them to take steps against anybody, company registrations and reporting requirements and all of that admin stuff that they seem to be very adept at.
Okay. We don't really have Twin Peaks anymore in Australia, though, do we? I mean,
we've never had Twin Peaks.
We started with Twin Peaks after Wallace, and now we have one peak, I guess it's APRA, and now we have ASIC, which seems to be bigger and bigger with every year that passes.
We've never had Twin Peaks, Senator Bragg. Twin Peaks recognises that the financial industry suffers from unique vagaries, systemic instability. So it is only in the financial industry that if ANZ goes bankrupt, it'll take down all of the other banks with it. But if Woolworths goes bankrupt, it won't take down Coles. If Virgin goes bankrupt, it won't take down Jetstar. If Foxtel goes bankrupt, nobody would notice. But if ANZ went bankrupt, or Commonwealth, or NAB, or even a second-tier bank like Bendigo, it would precipitate a financial crisis. For that reason, the Twin Peaks model identifies that there are two primary functions that need to be conducted in the financial industry: prudential and market conduct and consumer protection. And it further recognises that those two functions are at times antithetical to each other. So, for example, a prudential regulator will favour fewer banks that are smaller, that are bigger and better capitalised. A conduct regulator will favour consumer protection, which means more consumer choice, which means having more banks, which will unavoidably include banks that are smaller and less well capitalised. So you see this Dr. Dolittle push me, pull me animal that is pulling in two separate directions. So the Twin Peaks model specifically says, let's identify these as core functions, let's separate them, let's make them equal. So you have a dedicated prudential regulator and a dedicated conduct regulator. In Australia, we have a dedicated prudential regulator and a dedicated regulator for conduct in the financial industry and absolutely everything else to do with business, the economy, money, corporations, registrations, insolvency reporting, and everything else under the sun except partnerships regulator. And the remit is too wide. Now, this was the finding of the House of Lords, House of Commons review into the collapse of Northern Rock and Halifax Bank of Scotland. When the during the global financial crisis, when the United Kingdom abandoned the Mega Regulator, the financial sector, the Financial Services Authority, and adopted Twin Peaks, it was on the back of findings by the House of Commons and the House of Lords that the remit was too wide. When Wallace proposed the Twin Peaks model, what he proposed was a dedicated prudential regulator and then a regulator that would facilitate business. It would be a one-stop shop for business, registrations, reporting, all of that, basically virtually a glorified Officeworks. After the global financial crisis, people started to say, hang on a minute, this securities regulator, why isn't it protecting me when I lose money? Why isn't it protecting consumers? And it was only at that stage that it was there was an attempt to draft onto ASIC a culture that was concerned about conduct and consumer protection. By that stage, the culture that was inclined towards facilitating business was so deeply entrenched that at the 2019 Hayne Commission, Royal Commission, Commissioner Hayne said, stop treating regulated entities like customers. Well, they've treated them like customers from the word go because that's what they were born to do. And what we need is to, for the first time, adopt a Twin Peaks model. Now, Commissioner Hayne says at page 4, roughly about page 423 of the final report, page numbers vary depending on whether you're using the Word document or the PDF, about 423, he says, he examines this question of ASIC's remit, and he says, with adequate resources and the right leadership, I see no reason why ASIC can't discharge its remit. With the very deepest respect to Commissioner Hayne and the very greatest of respect to the extraordinary work done by the Royal Commission, I wish very respectfully to disagree.
Yeah.
In my view, Commissioner Hayne got it wrong, and he got it wrong because he misses the point. The point is not whether with adequate resources and the right leadership ASIC can discharge its remit. With adequate resources and the right leadership, anything's possible in the best of all possible worlds. But the fact of the matter is, which regulator, in which jurisdiction, in which industry has ever been adequately resourced? And as for the right leadership, well, that's just pot luck. And the fact of the matter is, the broader the remit, the more difficult the task, and the more difficult the task, the less likely it is to be achieved. Now, because the history of financial regulation all over the world is a history of failure, every single major jurisdiction that you care to think of, that you care to name, has suffered some form of financial crisis. Paul Krugman, who won the Nobel Prize in 2008, says there's a financial crisis somewhere in the world every 18 months. If financial regulation for those members of your committee, Senator Bragg, who are old enough to understand this reference, if financial regulation was a motor car, it would be a British Leyland Marina. It would just be a breakdown looking for a place to happen. So if you don't have the right regulatory architecture, you are guaranteed to fail. Whereas, if you do have the right architecture, then instead of being guaranteed to fail, it'll merely be highly probable that you'll fail. That's the best case scenario. Highly probable you'll fail. So you have to mitigate every single conceivable risk that you take as a learning from where things have gone wrong in other jurisdictions, and the first and most obvious, ASIC's remit is too broad.
Yeah. Okay. Could you take on notice some, to come back with some evidence around the breakup of the UK's Mega Regulator, and also some information about what you think ASIC is doing that it wouldn't necessarily need to do if we got the architecture right, in your opinion. I do, though, also want to ask you about the issue here of the referrals to the Commonwealth DPP. Now, in 2018-19, there were 86 referrals. 2019-20, 82, 80 in 2020-2021, then 70, and then in the last financial year, there's 41 referrals from ASIC to the Commonwealth Director of Public Prosecutions. Do you know what's going on here?
I think that's an exceptionally important point, Senator Bragg, and thank you for that question. The very eminent Professor Ian Ramsey, the doyen of corporate law in Australia, and George Gilligan analysed CDPP prosecutions over a 10-year period. They found that they relied on 86 sections over 10 years, 86 sections out of a possible 900. So one must ask what happened to the other 814 sections. Of the 86 sections they relied really only on 19. 19 out of a possible 900. The number of times that the CDPP used the ASIC Act for a prosecution constituted 2.1%. They claim a 97% success rate. Now, for me as a lawyer, members of the public might be impressed by that, but for me as a lawyer, if a lawyer says to me, I never lose a case, my response is, well, you don't take on many difficult cases, do you? So if they had used the full gamut of sections available, those 97% of cases that they've won, they may have been able to extract far higher penalties. The cases that they do take on, according to Professor Ramsey, are against individuals in small firms, not corporations, and they tend to be about administrative failures, not misconduct. And Professor Ramsey states as follows. He says, as discussed earlier, given the pervasiveness and extent of misconduct scandals in Australia, including the misconduct in the financial services industry revealed by the Hayne inquiry, these represent low levels of prosecution over a 10-year period. He goes on to say, given the scale of business misconduct in Australia in recent years, the fact that there have been only 715 prosecutions by the CDPP under two very significant corporate law statutes over a 10-year period is arguably low and reflects a limited level of criminal enforcement. Also, a relatively small number of sections comprise the bulk of prosecution activity over the 10-year period. For example, prosecutions under the 5 most extensively used sections in the Corporations Act constitute 37% of all cases and 47% of all counts for prosecutions under the Corporations Act. There were only 118 prosecutions of corporations over the 10-year study period. The data on penalties reveals that actual custodial services served are low, numbering only 114, and the median sentence is 16 months. Now, what happens, and I've canvassed this widely and I've tried my very best to understand how this works. ASIC submits a brief to the CDPP.
Yeah.
In that brief, ASIC will mention, will name, will list which sections it thinks has been breached. The CDPP can accept that, or the CDPP can ignore that and choose other sections. It is entirely at the discretion of the CDPP. However, doubtless, the sections that are named by ASIC will be of use to the CDPP. So I think we can conclude that the CDPP is under-resourced when it comes to expertise in the Corporations Act and the ASIC Act. But so is ASIC. Mr. Justice Perham in ASIC and Westpac said ASIC doesn't understand or know the law. So between ASIC and the CDPP, you've got two organisations that are across 86 out of 900, 86 of the easiest sections to prove because they're administrivia, and the other 814 they don't want to touch because it's too difficult, they're too conservative, and they don't want to lose. And
so I guess I come back to the question though. I mean, why do you think the number of referrals has halved in the past 5 years?
Because I think that ASIC is too distracted. Their remit is too broad. I get the impression from reports in the media about conduct exhibited by the leadership of ASIC that the organisation is in a state of chaos. They've lost sight of what they're supposed to do, which is why they run around federal parliament planting Dorothy Dixes, which is an effort to suborn accountability to the democratically elected representatives of we the people. That is scandalous in my view, Senator Bragg. It is outrageous that a Commonwealth authority is seeking to manipulate the questions that it gets asked as a form of accountability. It's unheard of. And I think that because they can't enforce the law, they're running around doing everything else but enforcing the law, lobbying members of parliament, and then refusing to say which members of parliament they've lobbied because apparently that's confidential. It's not confidential. Confidential information is information that relates to a current or imminent case that you're about to run. It does not relate to what you are doing on the taxpayer's dime by lobbying the duly elected representatives of we the people. It's an organisation that is out of control.
So, in terms of whistleblowers, there's been some discussion today about further reforms that we might recommend to whistleblower protections. Do you have any insight on this matter for us?
I do. Whistleblower protection in this country is like a bait and switch trick. You're told that there's whistleblower protection, and then anybody who tries to bring themselves under whistleblower protection is publicly crucified upside down so that all the other whistleblowers get the message. There will be no protection. And what they've done in the United States, which I think is very effective, because you must remember when a whistleblower blows the whistle, that is potentially the end of his or her career. What they've done in the United States is they have provided whistleblowers with substantial protection, including a payout on the rest of what they could have expected to earn in a career that they have now torched. I think those are the kinds of protections we need, and I think it's a very sad state of affairs, Senator Bragg. If I was the CEO of a company and that company wouldn't require whistleblower protection, because my attitude would be somebody who has the courage to blow the whistle is somebody who's just saved my job. And I'm not going to be persecuting that person, I'm going to be promoting them. Had Commonwealth Bank, instead of Commonwealth Bank persecuting Jeff Morris for blowing the whistle on Commonwealth Bank financial planning, if instead they'd said, well, he's got courage, let's get him to sort the problem out, they might have avoided a Royal Commission and they might still own a financial planning division.
Okay. Finally, do you think ASIC appreciates the role of short sellers and the role they play in capital markets?
I'd decline to answer that question, Senator Bragg. I don't know enough about it. Yeah, I would like to offer a comment, though, if I may,
sure,
on the testimony provided by Mr. Delosio.
Sure.
I found his testimony to be muddled and confused. ASIC is not a traffic controller. ASIC's job is not to stand on a highway directing traffic going, let the stream come through and we'll hold this one so that we can have optimal traffic flow. ASIC's job is to enforce the law, not to be a traffic controller. And where he says consumers must accept risk, they do accept risk. What they don't accept is fraud and theft. And when you charge dead people for financial advice or charge dead people, people you know to be dead, life insurance premiums, that's not risk, that's fraud and theft. And when he says what ASIC needs is greater clarity about the government wants when enacting legislation, my response is, if ASIC wants to know what the government's intention is when enacting legislation, read the legislation. It's in the Act. What the things are that you are supposed to prohibit. You don't need the government to hold your hand and mop your brow and say, there, sweetheart, this is what you need to do. It's in the legislation. And it's just this litany of excuses that, that reinforces this culture at ASIC that it's all too hard. Thank you.
Okay. Well, thank you very much for your evidence today, Associate Professor Schmerlo. We look forward to your answers to questions on notice, and we will now move to our final witness of the day.
So there you have it. The critical question: why is ASIC not doing what it should be doing? Well, it's a question of scope, it's a question of culture, it's a question of accountability. Let's hope these issues really do come out in the recommendations from the Senate inquiry, because as we've said before, ASIC needs transformational change, and in the meantime, ordinary investors, ordinary Australians are being left exposed. Martin North, John Adams, in the interest of the people. We'll see you next time.